He walked into court smiling, like this was all a joke. But what he was charged with? That's no joke at all. Ronald Simmons, 32 years old, is accused of punching his own mother in the mouth, hard enough to make her bleed, all because she refused to drive him to the store. Let that sink in. A grown man, angry over a ride, allegedly turns violent against the woman who gave him life. And this wasn't even his first time. As the judge begins going over the charge. Assault, family violence, second offense, the reality of the situation becomes clear. This is a third-degree felony. He's facing serious prison time. Years behind bars. Heavy fines. A permanent mark on his record. But instead of looking worried, instead of showing even a little bit of shame, he smirks. He laughs. He looks amused. That's when the courtroom energy shifts. The judge doesn't just read the paperwork, she digs deeper. She asks him directly why he hit his own mother. She reminds him he's 32 years old. Not a teenager. Not a confused kid. A grown man with a child of his own. And then comes the bombshell, he was already convicted in 2022 for assaulting the same woman. The same victim. His mother. Now the judge has a decision to make. The state recommends deferred adjudication, essentially giving him a chance to stay out of prison under strict supervision. But that chance comes with heavy conditions. No contact with his mother, mandatory anger management, family violence intervention programs, community service, drug testing, employment proof, and a complete ban on weapons. 6 years under strict supervision. The judge makes it clear, this is not a game. She warns him that his behavior sets an example for his own son. That violence doesn't just disappear. It repeats. And as he stands there, still trying to hold on to that smug expression, one thing becomes obvious. This wasn't just a hearing. It was a moment where arrogance collided with reality, and the consequences are only just beginning.
Document with your attorney, did you understand it? Did you sign it in all the appropriate places? Did you understand what you're charged with is assault, family, second offense? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine? Counsel, has the client been able to provide you with any defenses?
Yes, sir.
Showing you the plea bargain page, did you review that case? I'm sorry, did you review that page with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, the state is recommending deferred adjudication. And Mr. Simmons, did you understand that to be the entirety of your plea bargain agreement?
Yes.
Defense, is that the plea bargain agreement?
Yes, sir.
State, is that the plea bargain agreement?
It is.
Next, I'm showing you outside the plea bargain agreement. State is requesting that your deferred adjudication be for a term of 5 years. There'll be a TAP evaluation, no contact with Cheryl Simmons, no harmful or injurious contact with Ronald Simmons, and of course, there's an affirmative finding of family violence. I know that you all have put affirmative finding of family violence below the line, but if there is if I deem that this is a family violence case, there will be an affirmative finding of family violence. Does everyone understand?
Yes.
All right. Other than that, did everyone understand that I don't have to follow the recommendations from the state? Did you understand?
Yes.
All right. Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
Okay.
State, any evidence?
The state offers State's Exhibit 1 and all attachments, Your Honor. No objections, Judge.
Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, I review in State's Exhibits 1 and attachments. The court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are we proceeding with sentencing?
Yes, Judge.
All right, so first question I have, Ronald Simmons. Is Ronald Simmons married to your mom, and do they live together or no?
father, actually, Judge. And
Right.
I think your parents are still married, yes.
So they live together. How old are you?
32.
You're 32 years old. And is this complaint in this case your biological mother?
Yes.
Why are you hitting your mom? I mean, don't do this thing where we're shaking our head, we're trying to consider, because what I just read is you punch your mom in the mouth. We only get one mother. And it says that she was bleeding. I mean, if you want a jury trial, well, I'm here. Anybody who wants a jury trial is more than welcome to have it. But it appears that you have some anger issues because this is a family violence second. This is not a first. How old is your mother?
46.
When's her birthday?
May 30.
You sound very unsure. All right. So why are you hitting on your mom? Your parent doesn't want to drive you somewhere they don't have to. That's what via buses are for. That's what getting a job and getting your own car for. When this happened, were you living at that home?
No.
So you're coming over starting problems. And this previous assault family violence case, who was the complainant in that case? On March 25th, 2022, you were convicted of assault, bodily injury, family household, and cause number 669877. Who were you on probation for out of that cause number? What is their relationship? Can somebody look that up for me? Cause number 669877. It's a county court cause number, and see who the complainant was.
Cheryl Simmons.
Cheryl Simmons.
Yes.
So the same person.
Right. Sure.
What is your issue with your mom? I don't understand people who hit their mothers and their parents.
Right.
As you know, I'm from the old school of parenting. That most definitely would not have been allowed. And there are many things that I cannot say, but I don't know if, well, I do know. If I would have hit my mom, well, let's just say I would not be here as judge now. But people would probably be saying, oh, we remember Stephanie. She was such a nice little girl. So why are you hitting on your mom? And this is not the first time. There has to be a reason for it. Why do you think it's okay to hit your mother?
I mean, I could sit here and say I didn't, but I said no context. So answering your question.
Well, we have two cases with you involving your mom. So you're saying on both occasions, you never put your hands on her. And the fact that they're saying that she's bleeding from the lip, that's just, I don't know, something she did to herself. All right. And it says here you hit her with a closed fist, splitting her upper lip, causing it to bleed and swell. Grabbed victim's left upper arm with his left hand, holding her in place, and then punched her in the mouth with closed fist. And all of this because you wanted her to drive you to the store, and she said, no, walk. I don't know what people, in this day and age, people act like children can't ride the school bus. They got to have a nice car. People can't walk to where they need to go because it's embarrassing, or get on the via bus because it's embarrassing. If you don't have a car, can't afford get a car, you walk. All right. Are you employed? Would that be at Babies?
Yeah, babes.
Are those burgers better than Chris Madrid's?
Mm-hmm.
I'll see. You supposed, if you work there, you're supposed to say most definitely, but
Chris Madrid's is hard to beat, Judge. He's trying to be honest. He's under oath. He's trying to be honest.
okay. All right. Do you have any children?
Yes, ma'am.
What are their ages?
7.
And who does your child live with?
Mother.
Do you see your child?
So
Do you pay child support?
yes.
All right. And I ask these questions because Part of your conditions on probation, which sometimes people don't read all of the conditions, even though probation, I know, goes all of the conditions with you. Part of the conditions of probation automatically is supporting your dependents. All right. All right, 6 years deferred adjudication. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. No unsupervised contact with minors. No contact with Cheryl Ann Simmons, and that's with 1M. There's an affirmative finding of family violence. I'm going to want regular reporting by Zoom or in person. Regular UAs. I'm going to want field visits 2 times per month until further notice. The BIPP course, anger management, probation. Is there anything else he needs?
Connor, did you mention community service hours?
Let me do that. There's to be no harmful or injurious contact with Ronald Simmons. 200 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. Court is not requiring you to get that, but if you do, 40 of those hours will be waived. Parenting classes with triple P. Anything else you need from the court in order to be successful? I'm sorry? Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it? Because this is plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. And because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Good luck to you. You only get one mom in this world. And you know what? The way you're treating your mom, you're asking for your son to behave in that same manner. And your son may end up going before a judge because they're looking to you and you're.
He walks into the courtroom with a grin on his face. Not a nervous smile. Not the kind of expression you see from someone who understands the gravity of the situation. This is different. This is relaxed. Almost amused. Like he's waiting for something entertaining to happen. But what brings him here is anything but funny. Ronald Simmons, 32 years old, stands before the court charged with assault, family violence, second offense. According to the allegations, he punched his own mother in the mouth, hard enough to make her bleed, because she refused to drive him to the store. A simple argument, a small moment of frustration, escalated into violence. And this wasn't some heated altercation between 2 strangers. This was his mother. As the judge begins speaking, the formal tone of the courtroom contrasts sharply with his casual demeanor. She explains the charge clearly and slowly. Assault, family violence, second offense. A third-degree felony. That means potential prison time, 2 to 10 years. It means a possible $10,000 fine. It means a permanent felony record that follows him for the rest of his life. Most defendants, when they hear numbers like that, shift uncomfortably. Their faces tighten. Reality starts to settle in. But he keeps smiling. There's a lightness in his expression that doesn't match the weight of the moment. At times, he even seems to suppress laughter. And that's when the judge pauses. Because it's not just about what happened at home anymore. It's about what's happening right now, in this courtroom. Respect matters here. Accountability matters here. And the judge sees something troubling, not just the charge, but the attitude. She starts asking questions. Direct ones. Why did you hit your mother? What made you think that was an acceptable response? You are 32 years old. Why are you reacting like this? There's no yelling, no dramatic outburst. Just firm, focused questioning. The kind that forces someone to confront themselves. The details begin to unfold. His mother refused to take him to the store. An argument followed. Instead of walking away, instead of cooling down, instead of acting like an adult, he chose violence. A punch to the mouth. Blood. Police involvement. Arrest. And then the part that changes everything. This isn't his first offense. Court records show that in March of 2022, he was already convicted of assault causing bodily injury to a family member. The complainant in that case. The same person, Cheryl Simmons, his mother. The courtroom grows heavier with that revelation. This is not a one-time lapse in judgment. This is a pattern, a repeated act of violence against the same victim. The judge leans into that fact. She reminds him that this is the second time he stood in a courtroom because he couldn't control himself with his own family. She emphasizes that the law treats repeat offenses differently for a reason. When someone reoffends, especially in family violence cases, it shows something deeper than just a bad day. And still, that smile flickers. The prosecution outlines a recommendation. Instead of immediate prison time, the state is offering deferred adjudication. For some, that sounds like mercy. It means he won't be formally convicted if he successfully completes the terms. It means he avoids a prison sentence, for now. But it's not freedom. It comes with 6 years of supervision. 6 years of strict conditions. 6 years where one violation could send him straight to prison for up to a decade. The judge goes through the conditions one by one. He must complete a TAP evaluation. He must attend and complete a batterer's intervention and prevention program. Anger management classes. Parenting classes. Community service hours. Regular reporting to a supervision officer. Random drug and alcohol testing. Field visits. He cannot have any contact with his mother. None. Direct or indirect. He must maintain employment and provide proof of it. He cannot work in home healthcare. He cannot work with minors. He cannot have unsupervised contact with minors. And because of the affirmative finding of family violence, he cannot own or possess any firearms or ammunition. Each condition is read carefully. Deliberately. The list is long. The restrictions are heavy. 6 years is not a short period of time. That's 6 birthdays, 6 holidays, 6 years of checking in, following rules, proving you can behave like a responsible adult. The judge then shifts the focus to something deeper. She brings up his son. She talks about example, about cycles, about how children watch what their parents do, how they absorb it, how violence doesn't just end with one incident, it echoes. She warns him that if he doesn't change, his son could grow up thinking this is normal. That hitting family members when you are angry is acceptable. That disrespect is strength. The courtroom is quiet as she speaks. It's not just a lecture. It's a reality check. She points out that he is not a teenager. He is not 18. He is 20 years past childhood. At 32 years old, the expectation is self-control, responsibility, maturity. And yet, here he stands, charged for striking his own mother over something as minor as a ride to the store. The judge makes it clear that this is his opportunity. A final one. The court is giving him structure instead of a prison cell. Supervision instead of confinement. But she doesn't sugarcoat it. If he violates these terms, if he fails drug tests, misses appointments, contacts his mother, refuses programs, the court can revoke the deferred adjudication. And if that happens, the original felony charge comes back in full force. 2 to 10 years behind bars. The smile fades slightly as the weight of the explanation sinks in. This isn't just paperwork. This isn't just a temporary inconvenience. This is 6 years of living under a microscope. The narrator watching this unfold can't help but notice the contrast. On one side, a judge taking the situation with utmost seriousness. On the other, a defendant who seemed, at least at first, detached from the gravity of it all. Some might say 6 years of deferred adjudication is lenient. That a second offense against the same victim deserved prison time. Others might argue that rehabilitation is better than incarceration. That structured programs and supervision offer a real chance at change. But what makes this moment powerful isn't just the sentence. It's the confrontation between arrogance and accountability. A man who walked in smiling now faces 6 years of consequences. A record that will hang over him. Conditions that will restrict his freedom. A warning that the next mistake could cost him nearly a decade of his life. And at the center of it all is a simple truth. Violence inside a family doesn't get brushed aside. Not the first time, and certainly not the second. The judge's final tone isn't angry. It's firm, measured, almost disappointed. Because cases like this aren't just about punishment. They're about whether someone chooses to change. He leaves the courtroom not in handcuffs for prison transport, but under the weight of strict supervision. A second chance, carefully measured and heavily monitored. The question that lingers isn't what happened that day in the house. It's what happens next. Will he complete the programs? Will he learn to control his temper? Will he understand the damage caused not just physically, but emotionally? Or will the smirk return in another courtroom years from now? For now, the gavel has fallen. The conditions are set. 6 years. 0 contact with his mother. Mandatory programs. Strict supervision. No more excuses. No more laughter. Just consequences.